Good morning and welcome to PV Legal's daily newsletter. Today we cover a landmark ruling from the Madras bench of the Madras High Court, delivered on February 26, 2026. This judgment is vital for GST practitioners and taxpayers. The case is MS SPK & Co. versus Union of India, decided by Justice Krishnan Ramasamy. The court held that bunching multiple financial years into a single GST show cause notice is illegal, making any resulting order void ab initio. In this case, the additional commissioner issued one order for 4 consecutive years, 2018-19 to 2021-22, through a single notice. 6 traders challenged this in the High Court. The department relied on a CBIC circular dated September 15, 2025, claiming a single notice could cover multiple years. The High Court disagreed. Justice Ramasamy noted that Sections 73 and 74 of the CGST Act link notices to a tax period, defined under Section 2.106. Section 2.106 defines tax period as the period for which a return is required. Since returns are monthly or annual, a notice cannot exceed 1 financial year. Crucially, Sections 73.10 and 74.10 set separate limitation periods for each year, starting from each year's annual return due date. Bundling years distorts this and can unfairly deprive taxpayers of the benefit of expired limitation. The court cited precedents from the Madras, Kerala, and Supreme Courts. These include the Thorayal medical case and Caltex India Limited. It held that a CBIC circular cannot override binding High Court rulings. The orders were quashed, and the department was directed to issue separate notices within 3 weeks. Importantly, the court protected taxpayers by ruling that the original bunched notice date would count for limitation purposes if fresh notices aren't issued timely. This is a powerful tool for taxpayers facing composite demands. A writ petition challenging jurisdiction is directly maintainable. The takeaway is simple. The department cannot bypass the limitation period by bundling years. Taxpayers must check their notices for this jurisdictional error. Ensuring procedural compliance is as important as the tax itself. This ruling reinforces the rule of law in tax administration. Remember, Sections 73 and 74 are specific about tax periods. Each financial year is a separate unit for assessment and limitation. Strategic legal challenges like this one can save taxpayers from significant liabilities and lengthy appeals. Use the writ jurisdiction wisely. At PV Legal, we believe in proactive defense. Understanding the nuances of limitations can be the difference between a void order and a valid one. Always review your GST portal for composite show cause notices. If you find one, this Madras bench ruling is your strongest defense. We expect more high courts to follow this precedent, bringing much-needed clarity to GST assessments nationwide. Stay tuned for further updates. The goal of these legal updates is to empower every taxpayer, from small traders to large corporations, with the knowledge they need to stay protected. In summary, the Madras High Court has made it clear: 1 year, 1 notice. Procedural shortcuts by the tax department will not stand the test of law. For detailed advice on your specific case, always consult with a qualified legal professional. Don't let composite demands go unchallenged. That's PV Legal's analysis for today. Stay informed, stay protected. This is your host, signing off. Good day.